it out. Not the same song, different stuff. With me, it's right where you belong, girl. Yeah, right where you belong, girl. Yeah, I got this is not a remix, all I'm thinking of. Straight to like you did it, yeah, exclusive love. I'm a new edition, baby. I'm not saying I'm perfect, but I'm not just a remix. Brand new love. This is not a remix, all I'm thinking of.
Kim.
You guys are staff people. Want me to sit over there? Sure. Dennis, you can come up here. I did it last time. I just, not sure.
Got plenty of room. It's lonely.
I actually do. No, in the chair. It's exciting.
Oh, it's so close to you.
Yeah, if Ryan's on show, if you can scoot all the way over. Ryan's on his way. I have rain on not sure about.
Okay.
It looks like it's wet outside.
Let's get started. We're 1 minute late here. Welcome to the September 25th, 2017 study session, Littleton Planning Commission. We don't need a roll call. This is a study session with two topics tonight. One is continuation of legal. I call this legal 2. We had a study session about 3 weeks ago on major overall 10,000 feet in the air legal issues for planning commissions. And then the second item tonight is a floodplain primer, which I'll guarantee none of us have ever been through, since it's never come up in my 17 or 18 years. So, anyway, take it away. Jocelyn, you want to start, or you want to go straight into Steve?
Well, thank you, Mr. Chairman, members of the Commission. It is a pleasure to be here again. And tonight is really sort of the second installment. We've called it Planning Commission 101, which is basically talking about the mechanics of being a planning commissioner. There are some great books. One of them we have copies of. If you don't have a copy, Jocelyn will certainly make sure you get it, which is by the American Planning Association. And it is a detailed book on the role of a planning commissioner. But we have taken all of that information, and instead of having you spend a few hours reading a book, we're going to condense it and give you the important things that you need to know. And we've also had the Community Development Department has worked with us, so this is really a cooperative effort of both the Community Development Department and the City Attorney's Office. And this is the kind of thing that certainly we like to bring to the city, is multiple departments working together, all to help improve how we do things here at the City of Littleton. And with that, Lena McClellan is our Assistant City Attorney, and she's going to start that, and some of the slides she'll do, some I'll do, and we'll just kind of go back and forth.
All right, good evening, everybody. So, like Steve explained, we're doing just a sort of breakdown of how to be a planning commissioner. So we're going to start talking about the role of the Planning Commission in general, and some of this may seem a little obvious, but just bear with us as we go through. So the powers and duties of the Planning Commission can be found in Section 2-9-1 of the Littleton City Code, so all of this information is in the City Code. So one of the duties is general zoning regulations. Prior to final consideration and action by City Council, the Planning Commission will review all amendments to the text of the code, review all applications for original zoning, rezoning, and plan development plans, and forward any recommendations to Council. They also have final jurisdiction over conditional use applications, commercial mobile radio service facility site development, mouthful, floodplain management regulations, plan development overlay applications, and then on comprehensive plans, the Planning Commission will recommend to City Council comprehensive plans to guide future growth and development within the city, and that is subject to approval by City Council with changes or denial or remand to Planning Commission. And then lastly, development guides. The Planning Commission may make and adopt any design guidelines it deems necessary to guide development that occurs within the city.
I've had the pleasure over my career of representing a whole number of different planning commissions in different jurisdictions. And in putting this together, I sort of stepped back and thought, well, what are the characteristics, at least from a perspective of a lawyer, what are the characteristics of a really effective planning commissioner? And what are the things that if I was a planning commissioner, I'd want to know? And so this slide is really getting into that. And the first thing is, you're appointed with the idea that each of you are going to bring your own unique background to the commission. And that means you're not all going to agree. You're going to look at issues differently. Different people have different backgrounds. Some may come out of a profession. Some may not have been in the workforce at all. Some may be retired. Some may be working. All of these things impact on a person's background, and it's expected you're going to bring that background in looking at issues. Now, I have seen, when I first started out my career, I worked for a county, and one of the lacking things was the planning commissioners neither respected each other or the staff. Most planning commission meetings were long and contained arguments where commissioners would argue back and forth, and sometimes in a very derogatory way. There was a lack of respect for either each other or for the professional staff. And again, you should question your staff. You should always make them justify their positions, just like I would expect you to question me and make me justify my positions. But it's, I've seen it done where it has been done in a manner not of respect. And what that does is it really makes the commission less effective. And open to different points of view. And there, again, I once represented a planning commission and the chair was very upset. We're having too many split votes. My response was, that's a good thing. You should be open to different points of view. And the commission acts in many cases as an advisory body, and the more points of view, the better the advice. Not every commission vote has to be a unanimous vote. And again, as I said, I once had a city council member, she became elected to the city council, and she said, oh, I feel so reticent about asking questions. It's disrespectful for me to ask questions. That's like, no it isn't. You should ask questions. Ask lots of questions. That is a characteristic of an effective planning commissioner. And ask for more information. Sometimes I have to tell you, whether as a lawyer or a staffer, the information we give you doesn't answer your question. And we should always, it's perfectly appropriate to ask and say, I need more information. And these characteristics all, I think, are things that if a planning commissioner brings these characteristics to the body, they're going to be an effective member of the body. And they are going to be able to have the commission as a whole be more effective. Now, what is the role of City Council? City Council is ultimately the governing body of the city, and it exercises what we call legislative authority. Much like the state legislature does on a statewide basis, it sets the policies and laws related to planning. It adopts a comprehensive plan, and you'll hear sometimes the term general plan used. General plan and comprehensive plans are really the same. In this jurisdiction, Colorado, usually more often than not, comprehensive plan is used. If you were to go to some other states, you'd find general plan would be used. The council adopts zoning and subdivision regulations, and those are usually done through an ordinance, and they may make changes to those. And ultimately, they approve development applications for rezoning and subdivisions, and they appoint the members of this body. Now, in many cities, including this city, the city council has delegated some of their authority to the planning commission for certain zoning and planning decisions. And in those cases, the planning commission is acting, much like the council does, as a governing body. But in many respects, its relationship with city council is an advisory body. So what is the role of staff? I was at another board meeting here, and one of the commissioners was saying, well, you know, in the past, staff has told us what we're going to do. No, sometimes there's a misconception about the role of the professional staff and the role of the body. And it's important that all these roles be understood. Community development staff, and this would be also true in the city attorney's office from a legal standpoint, we're here to support the commission in doing your duties. We're not the commissioners. As one council member once said to me, Steve, no one ever elected you to city council, and no one ever elected you to city attorney. That was a very, very true statement, very valuable. Our job is to support you in your role. Now, staff is responsible for the processing and the technical review of development applications. And by that, we go through, we, of course, dot the I's and cross the T's and make sure all of the requirements of the code are met and all of the requirements of any city guidelines or standards are met. We also handle what I call the bureaucratic things, the scheduling of public hearings, the noticing of public hearings. And then we prepare staff reports, which really are the staff's written report exercising their independent professional judgment on an application, as well as handle the meeting minutes and the records, and provide the commission with other assistance. Again, a good staff should always be open, and I think we are, to if the commission wants something or needs something, that we're there to provide you assistance. Now, the city attorney has some unique roles different from the rest of the staff. We're the entity in the city that we provide you advice on procedural or substantive legal issues. That could be including meeting procedures, interpretation of the city code ordinances and federal and state law, and helping you craft language for a recommendation or a motion. At the end of the day, our job is to make sure that you're acting in accordance with the city's law, with state law, with federal law. And so what is the role of the city code? Now, in most states, Colorado has enacted what we call the Uniform Zoning Enabling Act. And what uniform acts are, these are acts put together by a group of lawyers, and they are designed to be sort of models for different states to use. And there are a number of uniform acts, and one of them is the Uniform Zoning Enabling Act. And it is a model act that authorizes local governments to enact ordinances to provide for zoning and land use. And if you were to go across, most states have adopted some form of that act. Not all of them, but most. Now, that state law, which you will find in the Colorado Revised Statutes, sort of sets the overall framework. It's a law saying, okay, local governments, you can now go out and enact ordinances and rules to govern development in your own community. Now, the city charter in Littleton is what we call a home rule city. It is a city that's chosen to exercise its powers under the Colorado Constitution to adopt a city charter. And it's literally our local version of the Colorado Constitution. It is the city's constitution, so to speak. And it establishes the framework for our government here in the city of Littleton. And then finally, we have the city code. It's Littleton statutes. If you went upstairs, you could see the maroon books, which are the Colorado Revised Statutes, all 46 titles. And like the maroon books, Littleton has the Littleton City Code. It's our statutes as a city, and it establishes our law and policy on how areas like zoning will be addressed. Now, because we're a home rule city, we can enact laws in our code that may even be different than state law. And the only time we cannot do that is when the state has exercised what we call preemption. The state has said that a particular subject is so important that the state needs to preempt all cities and regulate this as a state matter. One of the most well-known ones here in Colorado is the issue of oil and gas, which is regulated by the Colorado Oil and Gas Commission. The state has said this is a matter where we're going to preempt local governments in their regulation we want a statewide entity to regulate. And preemption is not unique to Colorado. I can tell you in all of the states I've practiced in or familiar with the law, and you have some degree of preemption. And it is something that happens on different issues and in different states. So what is the role of the comprehensive plan? Now there's two approaches to this as taken across the United States. And you could again go pretty much across the United States and you will see evidence of one approach or another. One is what we call a regulatory comprehensive plan. And these plans have actually the force of law. Good examples in Arizona. In Arizona, the general plan is a legal document and it has the force of law. All zoning has to be consistent with and conform to that plan. Now in other states, you have conceptual plans. They set forth aspirational principles for land use that should be considered in the land use process, but they're not mandatory. Now Colorado is kind of interesting because it's a mixed state. A local government can adopt a regulatory general plan, but it's not required to do so. And in fact, our general plan here in Littleton is a conceptual type plan, as is true in most of the state of Colorado. Most jurisdictions have a conceptual plan as compared to a regulatory plan. But you could do it that way if the city so chose. And we hear sometimes about guidelines, and many times people wonder, well, what are these guidelines? What they are is they're administrative rules on how policies recommended by the Commission and adopted by the Council will be implemented and applied. A good example is, let's take a subdivision. The Council will say that in a subdivision, a street must be built to city standards. It's clear. But it really isn't, because we have a series of questions that raises. How wide should the street be? It depends. That's really an engineering decision, because we look at what we call the classification of the street. If it's a local street, you would not want a local street being 64 feet wide, which would be essentially enough room for 5 lanes. You'd say, of course I don't want my local street that way. And the same would be true with things such as what type of curb should it have? What kind of driveway entrance should it have? All of these are provided for in guidelines where they're written, and it's really how the Public Works Department or Community Development would then apply that standard that the street must be built to city standards. Because we would then go through, we would look at other things that the city has adopted, like a street classification map, and apply all of those to these guidelines. And they're really much more technical than subjective. They're really technical things where we, for example, in drainage, we're going to be looking at the Urban Drainage District Manual for how we analyze drainage. We may also look at, there's a number of engineering criteria that have been adopted to look at flows and volume and the speed of flows, and we would look at all of those types of technical guidelines in analyzing a drainage submission. And they're public records. The city's guidelines, they're not like in some hidden drawer. They're a public record that can be looked at. Now, in some areas, such as design review and historic preservation, the guidelines would become very specific on how to comply with the adopted city policy. And you may even find specifications and diagrams and tables that an architect or an engineer or a planner can use to understand how to meet that requirement. For example, in the city I represented, design review, we had specific colors that in certain design districts you had to use. So we actually had a chart of the design guidelines, and you could see the different color palettes that you could use to meet the requirements. And that would be the type of diagram or specification you would find in these guidelines. You might hear in Colorado, because again, unlike a desert environment in Arizona, you have a much more diverse environment. Those guidelines may include things like overhangs and roofs and how the roof is managed, because those all become part of the nature of the community, particularly in an older community. And so all of those are part of the guidelines. Important thing to note is, guidelines can't overrule state law, city charter, or city code. Sometimes people say, well, they're using the guidelines to somehow overrule the code. No, they cannot be used to overrule the code. They have to be consistent with the code. But many times the code doesn't tell us how do you decide color lines. And frankly, you wouldn't want the code to do that, because the code is designed to be uniform in its application across the city. Think here of Milton. You have downtown. Downtown has a different character than county line. And you would want to look at different areas, and you might have different design criteria. The same thing, whether it be streets or drainage, all of those things, it's very impossible really to specify it in the code and have it be applied. And that's where you have those technical criteria within the guidelines.
Can I just break in and
Sure.
ask you something here? In Littleton, in the past, we've always talked in the planning commission about guidelines and standards, where
Yeah.
standards are this shall be done. Guidelines are more, depending on how they're worded, are more nuanced, they'll generally conform to adjoining residents. That could be open for interpretation. So guidelines that I've experienced in the past are not written in stone. They are open for a little bit of wiggle room, let's call it.
And you could do it that way, and many times it is done that way in something like, for example, a specific design plan. It will have guidelines, and if you look at the plan, it would say these guidelines are general. You make an effort to try to meet those, but the staff is given the ability to have discretion in whether you have to meet those in every case. Now, sometimes we will have guidelines. A good example is, and you might call them guidelines, you might call them standards, engineering design standards.
Right.
Where those are not going to be open to attempting to meet, we're going to say if you're developing a new subdivision, and the subdivision is going to hook into a wastewater collection line, and based on the amount of waste generated, it needs to be a 15-inch line. What we're going to say is, we're not going to say, well, I only want to build a 10-inch. We're going to say, no, the wastewater collection study you did demonstrates it needs to be a 15-inch. Our standard then is a 15-inch. You must build that. So sometimes standards and guidelines will get used interchangeably, and that can create confusion. What I'd like to think of it is, we in the city here are moving towards creating some standards for different types of technical items, because one of the concerns we have is we don't. Sometimes it's very difficult to understand what we're doing because we don't have the technical standards. So what we're going to be trying to do is, usually our technical items are going to be called standards, and we're going to try to leave the guidelines more to things like character plans and things where they are aspirational. But sometimes you will see something maybe from the urban drainage district or maybe from South Suburban where it's guidelines and they really attempt to use it as a standard and they apply it as a standard. So there is some confusion there, but we're going to try to stay more with standards being absolutely mandatory and guidelines being something that we will use to interpret a plan, but staff will have more flexibility in their administration.
Anything to make anybody applying knows, okay, I've used the word standard. These are standards, so it's like, uh-oh, I have to comply to this.
Yes.
And I have some guidelines. Okay, I can negotiate.
Yeah, and we're going to try to be a little bit more in that line Because I think one of the problems is that sometimes when you start using these terms interchangeably, and they do it in other jurisdictions as well, a good example is concept plan. Concept plan, and depending on the jurisdiction you are here in Metro Denver, means very different things in very different cities. And you think, well, that's an easy term, concept plan? It really isn't. So we want to try to avoid that. This is mine or yours?
This is mine.
Good.
So now we're going to move into more about the meeting side of things. So we're going to talk a little bit about effective meetings. So all authorities, boards, and commissions in the city of Littleton are governed by the City Council legislative rules. And as a member of the Planning Commission, you are responsible for reviewing and understanding this document. If you have any questions about it, you can certainly ask staff or the City Attorney's Office, and we'd be happy to walk you through it. The legislative rules are going to include things like the order for meetings, certain parliamentary rules, and go over certain types of motions and things like that.
You can find it on the city's website. If you look under the City Council tab of the city's website, it's right there.
And just to that, if you guys want copies of it, I mean, we pointed it out where you find it electronically, but if you want a paper copy, we can certainly make copies of that. And as you know, when at the dais during the meetings or when it's a formal meeting, Denise Cerny has made kind of a cheat sheet of kind of progress of structure of how sections of the agenda are being managed. So another way to try to help create how we walk through each of those items.
So there are generally 2 stages to a meeting, and I'm sure you have all experienced this. There's what we call more of a fact-finding stage, and then your deliberation stage. So in your fact-finding stage, this is going to be where staff, the applicant, and any other interested parties are going to present their positions. At this point, as planning commissioners, you guys should be keeping a more neutral, fact-finding mindset and asking only clarifying questions, really avoiding, at this point, taking any positions or vocalizing them. You can certainly be beginning to develop in your mind, but trying to stay more neutral. At this point is when you would get, like I said, the staff presentation, which you are, I'm sure, all familiar with at this point. At that point, the staff is going to present an overview of the report, the basic facts about the application and the property, the land use regulations or standards that are relevant, any policies, and then recommendations, and respond to your questions. The applicant will do their presentation, and then also there'll be public comment. As you all know, there are certain limits that City Council has set on public comment. It's 3 minutes. They need to be respectful. There's time for public comment about general items that is given at the beginning of the meeting. During this point, you are giving public comment related to that application. And then your final stage is going to be your deliberation stage. This is where you're going to have the opportunity to discuss amongst yourself, amongst the commission, make sort of your decisions about how you want to move forward with the application, and obviously do any vote. Okay, now we're going to go into a little bit about the different hats that you may wear as a planning commission and planning commissioner. Your first one is going to be your quasi judicial role, and as you can see, this is your judge's wig moment.
Can I get one of those?
Well, it is right before Halloween, we're gonna have that, right? Yeah. But you have to wear them on TV.
Yes.
Everyone.
The City Attorney's Office is working on some guidelines about quasi-judicial guidelines. It's still in the draft stage at this point, but it is something that we are working on, and you will receive that when it is finalized. But that will go into some more detail about this. So, we're going to go into a little bit more detail about what it means when you're wearing this quasi-judicial wig. So the types of things that you might be doing while wearing this wig would be things like rezoning, plan development and plan development amendments, and plan development overlays. So this is like, think your public hearing situation. That's when you're going to be wearing this quasi-judicial wig. So going into a little bit more detail about what happens at a quasi-judicial proceeding. So the parties are the city, the applicant, and sometimes somebody that we like to call an intervener. That does not happen very often, but that is a person that is by law given the legal right to participate. That's going to be very rare.
For instance, give me a for instance.
For instance, you could have a situation where a person lives within a specific zone of interest around a rezoning where they have a right to object. And because the statute gives them that kind of right, they can actually seek to participate in the process. It's very rare. Once in a while you'll see it with certain types of planned development districts where a party who already lives within the district has a right to participate. I would say that I have only seen it maybe once every 2 or 3 years in jurisdictions where I've been, but it does come up once in a great while. And so when they do, we would always tell you, this case has a party who has a legal right to intervene. Here's where they get their legal right to intervene, and they have informed us that they're going
to participate in the fact-finding stage?
They actually get to participate in the fact-finding. They can make a presentation to you, just like the applicant, and they get an opportunity in theory, they could actually file a Rule 106 case because they're, by law, a party who has an interest in the matter. So, I mean, it's a very rare thing, but they actually are there.
And then, okay, so then some of the sort of pre-hearing stuff. Once we are aware of a matter, you will be given notice. We're briefly going to go in very quickly about ex parte communications. Once notice has been received, at that point, that's sort of your trigger that you should cease any ex parte communications. That would be with city staff, parties, or other interested persons, or undertake things like individual site visits, investigations, or solicit expert opinions. If you want to do one of these things, it should be organized through staff and the opportunity provided to all members at the same time, if possible.
I have a question about that. That's not what we were originally told, that we were told we could do individual, just go check out the site and stuff on our own, just don't talk to anybody when we're doing it.
In a quasi-judicial, I would tell you I think that's inappropriate. I think the appropriate way would be that if you want to see a site, because then the issue becomes one person has access to information that others don't. The better approach I recommend in quasi-judicial matters like this is that we as a staff, we provide it to everybody. Now maybe only one person says that they want to come. But the difficulty that you get into is my concern is always that in a quasi-judicial, you are all basically acting as a judicial body. And so it's important to make, now many times people will say, well, I don't want to see the site, I don't care. Now another way that sometimes it's done as well because people want to see the site is staff will go out and video the site and submit the video as part of the record. And sometimes that's done. But to me, we had in a totally different quasi-judicial matter, a person say, well, I want to collect these documents from an outside party because I want to answer these questions. Well, the appropriate thing would be to say, staff, I think this is relevant. could you collect these documents so we provide them to the whole board? Because otherwise what happens is one person on the board has a piece of the record that nobody else has. And that is really contrary to the idea of a quasi-judicial proceeding.
I would think it would be our responsibility to get out to the site regardless of when. That's how I've always done. I could see also if you wait and try to get an organized trip conducted and chaired by staff, I'm sorry, I can't make it. Yeah, I can make it this day. It gets extremely confusing, complicated. It gets to be a mess. So I don't see going to the site on your own 2 days before a hearing. It would really have an impact on you having more information that somebody else, some other commissioner will say, can't get to the site or doesn't want to get to the site.
Well, I mean, the only difficulty is that in a quasi-judicial matter, because you're really limited to the record, then the question that comes up is, what is the record? That's not, in essence, in a quasi-judicial matter, unlike a legislative matter, you're limited to only deciding based on the record. And so that now, is that part of the record when it wasn't done as part of an organized matter, that it becomes an issue if somebody does want to challenge that, okay, a matter outside the record was considered.
It's the one, we had another attorney a few years back that said, avoid going to the site whatsoever. And my reaction to that was, okay, the planning commission would be the least informed people in the room.
I don't think that works.
It's not right.
I don't think that works. I think frequently the site is a very relevant thing that needs to be part of the record. Because, I mean, there are characteristics. A site that has washes through it, drainage is going to be a characteristic that's going to enter into your deliberations. And that is something where that information needs to be part of the record so that you have a complete record to consider. But the danger is that having people collect information and having things that are outside the record being considered in a quasi-judicial proceeding, because the court is looking at whether the decision was based on the record or based on material outside the record. And from the lawyer's concern is we want the decision-making, whatever that decision is, based on what's in the record.
I hear what you're saying, but logistically, if we get the information Thursday night, sometimes not till Friday morning, when are we going to schedule it?
Then it may have to be continued so it can be scheduled. The fact of the matter is there's no constitutional right that you have to have a hearing on a set date and it cannot be continued. In fact, there's a case called Del Monte Dunes versus City of Monterey, where the United States Supreme Court found that 13 years of continuances was excessive, but that merely one continuance or two continuances is not. If there's a situation where you feel you need additional information in the record, then it's very appropriate for the commission to say, well, we think we need to continue this to another date so we can have that information as part of the record.
I don't know that we're saying that you all necessarily have to go together. I think we're just saying you have to tell us that you're going.
If I tell you Friday
Right?
afternoon,
We don't
that I
have to go
intend
as a group necessarily, because if you go as a group, we'd have to notice it as a meeting.
Yes. No, I mean, I think our concern is we simply want to make sure whatever is being viewed by you as a quasi-judicial body is part of the record.
So if I tell staff I'm going to go out there Friday afternoon to look at the site, that's adequate enough and I can go out? And abiding by our previous rules, which say, as you said, Robin, not not talk to anybody, not get any discussion. If a neighbor comes out and wants to speak to you, you just go, take a look, and leave.
I think if that's what you've been doing, we can work with that. I would tell you my preference is that the site visit somehow be documented so we can actually show that it was done this way and put in part of the record. But the key for me is that we simply have it. Somehow we're able to document that as part of the record.
How do you see this happening, Jocelyn? I mean, this is falling back on, if we want to do what Steve is saying, to go as a group, it's going to fall back down on you guys on taking us, being
I know,
there.
I'm having my life flash before me, like, how we're gonna get this done.
So how do you see this happening to make sure that we're meeting the requirements, but able to do something and not cause?
Well, I'm wondering if one thing maybe we can ask about, because I agree, I think different jurisdictions have done it differently, and different attorneys have given us different direction in the past as well. And maybe what we're saying is that generally what we have been saying to the Littleton Planning Commission, at least since I've been here, is okay, in your own due diligence, just to prepare yourself for the meeting, it's fine for you to go and look at the site, but no speaking to people and really any of that type of stuff, if that happens, then to disclose that at the meeting. But if you're just doing your own due diligence and driving by or whatever, then we've allowed to do that. So maybe what we could do to alleviate some of that is to say, hey, as a requirement, here's the expectation of Planning Commission, and that everyone goes to the site prior to, or some version of, you know what I mean, to make it part of the structure.
Or even at this point, if you're going to do what you've been talking about doing, then that information should get communicated to staff so that what we want is we want that in the record. We want to know that commissioners did see the site, because one of the issues that comes up is in a Rule 106 appeal is going to be that information was considered outside the record. So if we have it in the record that, some commissioners went and saw the site, then we at least have it in that record.
So
So maybe each at the meeting,
They
then
say, yeah.
everyone can offer when they went by the site, or some version of that.
Or it could be done even by email. You could send Jocelyn an email. Jocelyn, I did see the site on this date, so we have some ability to show what is in the record.
But is that almost in the point of disclosure at the hearing? Say, like Robin would say, I visited this site on Saturday and I
Whether
went
it's done
out.
at the hearing or whether it's done by an email, that can be part of the record.
Honestly, so we don't lose anything,
Better.
in my opinion, the easiest way would be to everyone bring that information to the hearing and offer it.
Well, we could ask outright at the beginning,
Right.
who was
Who's
visited the
went
site?
and when, yeah.
Did anybody talk to,
Right.
a neighbor? No? Okay,
Right.
let's move on.
Yeah, we could incorporate that into how you
Could
introduce
we get
the
like
item.
no more than a half page, just guidelines for site visits that allow a little more legal room than your original strict interpretation?
Yeah,
No.
yeah.
And I will work with, because we recognize that, again, the department has a number of different things it's doing. So we
Yeah, we could do that.
do that.
We can get you that.
I think,
No, I was just gonna say, I mean, I'm fine with what you're suggesting, but if we're doing that and you want it to be consistent, why not run out with a camera phone or a phone and just take, a 3-minute video of the site that has pertinent features so that everybody sees it at the meeting as part of the record in the way you're indicating.
how about, this is a great topic that we will come back to you with some structure around.
It'll be hard to sort on that
It's a good
page.
question,
Yeah.
we just want to make sure we.
But it's good
manage
feedback
it.
for your staff presentation talk that we had the last time, just ways to improve. And I know you guys include photos and
Yeah, we
things like
already
that,
do site photos, so.
which is always good, but
We'll see.
this helps.
We'll see how we figure out how to manage that. But
There's
yeah.
just so many different ways to look at a site.
Right.
And, are you gonna walk all the way around and, give the 360?
Well, that's what I mean. So we
that's
may
a
just
whole-
keep with photos and give you some structure about a site visit.
For now.
If that's,
Yeah.
to start.
How to climb up barbed wire fence, all that good stuff.
And so, in lieu of Jasper, we'll have to work with you on the mechanics of all of this.
move on. So, some things to consider during a public hearing, remembering that as commissioners you must be fair and impartial decision makers. You should be keeping an open mind and basing your decisions on the evidence presented at the hearing and any applicable law. You should be refraining from making any public statements prior to the hearing, either for or against the application. And if due to a conflict of interest or any bias or other factors, a commissioner does not have an open mind and cannot base their decision on the evidence or applicable law, you should be advising the commission of this and withdrawing any participation in the hearing.
Could you be specific on what a conflict of interest or bias would be?
That is a very large topic to cover, but some of the sort of the basic thing would be if you have any sort of monetary interest in the project, if you are somehow very closely related to someone who's the applicant.
Your spouse, for example,
Yeah.
is the title officer in the title company that's handling the transaction between the seller of the property and the applicant.
And this is really this can have a very large range. So you can range anywhere from it's so much a conflict of interest or a bias that you have to recuse yourself to it's maybe so minor and so far removed that you just need to tell everyone and disclose it at the hearing, but you can still sit on the dais and make a decision. So it really can run from either end to end, and it's really going to be very specific to the instance, and
A good thing would be to, if you have a,
If
yeah, if you have
question,
any
ask
concern
that
that
before the meeting.
something smells funny, that's the time when you would reach out to Steve and I and say, hey, I've worked with this architect before. This architect built my house, or this architect built my cousin's house. Is this going to be a problem? At which point we will tell you, yeah, we think you should disclose it, but you're fine to, still sit up there and help make the decision, or we'll say, no, you need to disclose this, and we think you need to recuse yourself.
And if it's in a meeting environment, because we often don't know who's presenting or details of the application before.
I have had in another, on one of the other boards that I work with here in the city, I have actually had one of the board members come to the meeting. They saw who the applicant was. They came to me and said, I have this connection to the applicant. It was fairly tenuous, and so we told this board member, disclose it, but you are fine to continue on. But that was at that moment, disclosure and decision. So certainly you're not always going to know who it is at the time. And so certainly come talk to us in our seat and let us know.
What if you're up there and the meeting started and then you realize there might be a connection?
You can always stop and ask us a question.
And I've had that happen over my career, where a couple of times board or elected officials have suddenly looked and said, can we have and usually they will approach the chair, can we have a recess? I need to go talk to the city attorney. And that can happen. And that's actually the proper process would be for you to ask the chair for a recess so we can have that conversation.
But living in a particular neighborhood that's near a case is not a bias or...
No.
Not necessarily, no, not necessarily.
But if it's something that you are adjacent to, it's like right next door to your house, and it could have an impact on you, that would be an example where you should disclose it.
And you should disclose it, and you may well have so much of an interest from a quasi-judicial standpoint that you can't participate. You may know the neighbor, you may have talked with the neighbor about what a great idea it is, and you may have been had lots of kind over watching basketball, talking to the neighbor about, oh yes, you need to change your house this way, and this would be a great thing, and do a zoning case. And at that point, you, while you may not have a conflict under the state statute for conflicts of interest under the city code, you may have so much information from a quasi-judicial standpoint, you can't participate.
I think what's important to remember is that, remember the wig that you're wearing? You guys are essentially acting in these moments almost as a judicial, or as a judge, the judicial body, and so just think about it in those terms. You wouldn't want the judge at your criminal case to be, married to the to the prosecution.
Or have them be next door to the prosecutor.
Or have them be, somehow related to your case. So just, I think it helps to remember that hat that you're wearing when you're thinking about these kind of things.
I think the other thing that's happened a lot, especially in a smaller community, is you'll be at the grocery store, right? So you're just there buying your groceries, and then all of a sudden someone comes up to you and said, hey, you know what, my application's coming before you next week, and I really want to tell you 5 things about it, and I really want you to vote for it, or whatever. So those are all things that you just disclose it, say, hey, someone approached me at the grocery store, but I told them I can't talk about it. Just those type of things. You just make sure you're disclosing any of that.
Yeah, my neighbor cornered me at the mailbox.
Yeah.
That sort of thing. So yeah, then like we talked about disclosures. It's just important that if you have something like that, or you realize something at the last minute, or you had that run-in at the grocery store, that you take the time at the beginning of the meeting to disclose that, and depending on the sort of severity of the conflict or the bias, at that point you either recuse yourself, or it's just, hey, an FYI, everybody, I just want to be above board and everyone to know what happened. Okay. Go through these kind of quickly. You guys all know about this. Start with sort of the order of things. There's the staff presentation, obviously applicant presentation. Like we talked about, this magical intervener that we don't see very often. We open the public hearing. We're going to do, and this is more of a general guideline, so generally, when you have a quasi-judicial proceeding, you may allow for a final presentation after the original one, and you may allow for final arguments. And you're going to notice that there's an order that sort of permeates through the whole thing. It's relatively going to go staff, applicant, and any other third parties if there are any parties. Obviously, generally, we have followed the procedure in the city that if you have questions of staff, you can ask those at any time. And obviously then you're going to close, and then you're going to deliberate and make your votes. All right, we're moving on to a new hat. This is your legislative role hat. There's really no hat for like a Uncle Sam. Uncle Sam hat. So when are you going to wear this hat? So this is going to be things like when you're doing things like creating updating the code, or adopting design guidelines. So that's going to be when you're acting more in your, obviously in your legislative capacity. That's when you're acting as, think of yourselves almost as like a Congress or council.
Now, the important thing to keep in mind when you're acting as a legislative body is that you really are looking at things in terms of having a rational basis. Unlike a quasi-judicial, where you're looking at the record, here you're looking at all of the information and it could even be information that's not per se part of the record, but that you are simply looking at that with a rational basis. So it's very important when in quasi-judicial, you will hear us always talking about staying with the record. Here, because you're, just like in legislature, we've all been reading about the Affordable Care Act and how different persons have taken different positions. And some of what their positions are information from constituents. It's not part of any record, but it has influenced them on a position. And in a legislative context, that is how a legislative body works. But you don't do that in a quasi-judicial
So that's why when we're doing the code updates, we can talk to you, give you study sessions and talk to you about all this stuff, because we're in that legislative, that's the difference. You don't hear about the land development cases coming ahead of time, but we can have a study session, talk about code changes, comp plan, design standards, all that stuff, because that's your legislative role.
And really think about it, it's managing it for all, right? So the update, the decisions we make in the legislative capacity generally impact any application or any land use in that zone district or whatnot. So that's the other thing. Yeah, a legislative.
They apply citywide.
Right. Yep.
Well, you know, if you're thinking like if you're Congress, you're making laws that affect a wide swath of people. If you're the Supreme Court, you're deciding on a specific case.
Right.
So that's, you know, those different roles. So the last role that we're going to talk about is your regulatory role. And for this one, you are wearing your Smokey the Bear hat, because this is like an administrative agency. And some of the things you might be doing when you're wearing your Smokey the Bear hat would be things like looking at floodplains, subdivision, preliminary plats, and conditional use permits.
And these, you might think of this, I mean, the fancy legal term is adjudicatory. What it really means is that you're looking at these in terms of reviewing what the agency, in this case the staff, has recommended. Now, in administrative law, there's some general principles that you follow with this. The first is that you defer to the expertise of the staff, so that, in essence, the staff is presumed to have an expertise in doing what they did. And this standard of review is really that if the staff's action is what we call arbitrary, unreasonable, or capricious, which are, again, three fancy legal terms. The easy answer is arbitrary means it's simply done without thinking. It's just staff did it because it's staff and they didn't think about it. There's no justification, there's nothing. Unreasonable is that a reasonable person could not possibly come to this conclusion. It doesn't mean that a difference of opinion is not unreasonable. Unreasonable is we're looking at the evidence, there's no possible way to come to this conclusion. In essence, you can't get from A to Z. And then capricious is simply defined as unthinking. That in essence, the decision was made without looking at any of the relevant facts and evidence and codes and guidelines and standards. It was just simply made. And if any of those factors exist, a staff decision could be overturned. But if it's simply, well, I disagree with the staff decision, I don't like it, but it's perfectly reasonable and they considered all the evidence, I've just drawn a different conclusion. Normally, an adjudicatory body, when it functions in this capacity, that's not an appropriate reason for acting. So you're really sort of the review, the administrative review of the regulatory decisions made by staff.
Think about your hats when you have a case. And we might question which hat, and if we hand them out, you gotta wear them, right? So
Yeah.
so we're gonna come out, and hand them out, okay, then select them at the end.
And one of the
Keep the
things
symbols the same.
one of the things we will try to always do is when a matter comes before you, what I like to see is in the actual communication at the beginning of the matter, we'll say, Commission, this is a quasi judicial matter, or this is a regulatory matter, so that you're kind of thinking, oh, okay, that's the approach I need to look at. Because it does get kind of confusing. I mean, for whether it's a city council or commission, when you're functioning in these different roles. Because suddenly, the way that you look at things and the rules, they change. And so part of our job as staff is always to make sure we define that and tell you what this is.
So Steve's offered to wear the hat, so you would always be able to just look at Steve. Right?
That's true. I will bring my hat.
gonna keep all three of them under the chair.
Yeah, you'll put them on and you'll know, see?
So with that, we've talked about staff, but let us open this up to any questions that you might have as commissioners, be either Jocelyn, Carol, Lena, or myself.
I think this came up the last meeting we had, but I think you broached the subject again, so I'm going to ask it again. Much of what we do from a land use perspective involves looking at information or projects in order to determine, at least first and foremost, that there's consistency with a comprehensive plan and or neighborhood plan and so forth and so on. And to extend that, then if it is, that's fine. And if it's not, then you have to find that there's a change in conditions or change in use or manifest error in the original zoning map, for example. But if we're working off of what's you're describing as a conceptual plan, if our comp plan is a conceptual plan, getting to 7 people sitting up there to determine that a given project is consistent with a conceptual comprehensive plan sounds entertaining. But
Wow, and one of the differences is, if we, for example, if you were in a jurisdiction that had a regulatory plan, part of the regulatory plan would be you would have a public facilities element. And you would, a public facilities element, which would identify schools, parks, all kinds of public facilities. And that zoning case would actually have to quantify its impact on those public facilities and demonstrate that it meets the requirements in terms of for example, recreation centers. They would have to show, well, we're meeting the need for additional recreation facilities because we're going to be paying park and recreation impact fees, and that's how we're going to meet this need. And so where you have a regulatory plan, you get into that level of specificity in the zoning case, tying back to the plan. Where with the conceptual plan, we have a series of principles. And I'll be honest, some of those principles, different people could see those differently. I suspect if we were to take a zoning case and Jocelyn and I were to look at those principles, we'd come to different conclusions because they're fairly broad, they're very conceptual, but different people could see those principles differently. Now, if the city was to move to a regulatory general plan, then you would see a much different type of analysis that would be done.
So what you're basically saying, though, is if we as individual commissioners have to stipulate we have found that a certain, or do we have to state or make some sort of a representation that we find that a given project meets the attributes of the comprehensive plan or it does not, and then we deliberate, and ultimately that's how the decision ends up getting made anyway.
And well, yes, what would normally happen is usually in the staff report, the staff is going to, which is part of your record, the staff is going to have given you its analysis of whether this particular zoning application conforms to the general plan or not. Now, what you may as commissioners say, well, yes, I've looked at the staff report and I've seen the staff analysis. I've also looked at the principles of the comprehensive plan. I happen to disagree in this case with the staff report, and here's why I want to disagree, and I want to put that on the record so my disagreement is part of the record. But normally, one of the things we're trying to make sure we do in our staff reports is that we actually identify, we've looked at the comprehensive plan, and here are the principles that we think it's met. Or if we had a case where we don't think it meets the comprehensive plan, then the only reason to bring it to the commission versus sending it back to the applicant and asking the applicant to rework would be if the staff felt some reason that there was some need overriding need that the comprehensive plan didn't address or whatever, that would be a very unusual situation, I think, for the staff to bring you something that would be at odds with the comprehensive plan. I wouldn't say it never would happen, but it'd be very, very unusual.
But from an interpretation standpoint, I mean, it's incumbent upon us to look at those documents and start, yeah, we need to read the staff recommendations and weigh that as part of the process, but we also need to look at the plans of the neighborhood plans or whatever, the comp plan, and put them together with the evidence being presented and see if we can come to the same conclusion.
Yes, because
And also looking at the applicant can take the same sentence and
Well,
interpret it entirely different ways. So you have to take three. You have
Yeah.
to do
No,
staff, your own interpretation, or what you think is in the, and the applicant.
and those
And the public.
would be part of the record. The relevant and applicable portions of both an area plan and the comprehensive plan would be part of that record that you're just like a judge does. I mean, I've tried many a case, and frankly, a judge has drawn different conclusions on the evidence than I would have liked to have had them draw. That's just the nature of the judicial process, and it's appropriate. There will be times where you'll draw different conclusions than the staff.
But Steve, can you talk a little bit about due process? Because we can still bring cases forward that may not comply with the code because we can't deny anybody due process.
Yes, because and that's an important point to carry on. And particularly with zoning, the applicant under the U.S. Constitution has a right to two things: what we call procedural due process and substantive due process. And these we could spend all night just talking about in great detail. But to simplify this, procedural due process really means the city followed its rules. And the applicant has a constitutional right to the city following its rules. Substantive due process means that the city followed the U.S. Constitution and any other applicable law. So, a good example is the staff cannot say, well, gee, we hate this rezoning. We're simply not going to let it proceed to the commission. That would be a denial of substantive due process. Now, the staff can go through and say, well, your application doesn't meet these criteria, you need to go back and rework it. If the application meets all the criteria, staff may recommend against it and say, we think for these reasons, based on the record, we don't believe this zoning should be approved. But the applicant has a substantive right to come to you and have you act on it.
And also that the applicant can also take a negative recommendation from the planning commission, still proceed through due process and go to city council.
That's true too. I mean, you could, again, the applicant has an appellate right to go to council if they don't like your recommendation. And we can't say, well, we're going to recommend it against it. The commission recommended against it. You can't go to council. No, they have both a procedural due process right and a substantive right to go to the city council.
When you're acting in your quasi judicial and making a recommendation, when council has the final decision,
Yes.
right? You
And
still bring it forward.
So they have that right. And yes, we will work with the applicant and we will make it very clear to the applicant, you obviously, we have a right to go, but you should understand that there's going to be a negative staff recommendation and these things. But if you insist on going, we're not going to stop you from going.
So sort of a follow-on to that, speak. Can I ask a question? Sorry.
No.
Oh, okay, I didn't want to interrupt you, but when there's a staff report, who is staff? And does it represent the entire department? Does it represent the city attorney's office?
The staff report is a report that covers all of the departments. Now, once in a while, we'll have legal issues that fall outside the staff report. And so then, because we're the lawyers, we'll speak directly as to those. But the staff report is really the position of the city staff. Now, sometimes, because we may have technical issues that involve, say, for example, a traffic engineer, staff will include their comments in the report, but then have them present and saying, listen, there will be some technical issues here which we are going to ask as part of our staff presentation to have the city traffic engineer address because they're so technical in nature that we really want them to address it.
And the staff report goes through a process. Is that what you were going to talk about?
Yeah.
That everybody reviews it.
Yes.
And I was also going to say, when Steve's talking about if there's a separate legal issue that we're going to address, that would generally be separate from the staff report. And you're going to see that as a legal memo. And depending on what type of issue it is, it may or may not be a confidential legal memo. But if something rose to that level, you wouldn't necessarily see that in the staff report itself.
The staff report is reviewed by, well, when you get to a staff position and write up the staff report, it's done as a collective. It's not, think of it like the Borg in Star Trek, right? It's a collective, right? Okay, so just revealed I'm a Trekkie on TV, so there you go. So, but it's like a collective, right? And so staff as a collective has reviewed this, and then it goes through Jocelyn, and it goes up to legal, and it goes up to the city manager. It goes all around through this whole process, and everyone's read it, everyone's on, and everyone comments on it. So it's not just one person making an isolated decision.
Or department, because
Department,
sometimes,
yeah.
depending on what it is, public works, whether it's traffic or some other drainage, whatever it says in the code, everyone's had some piece of it, including, that's why in the back, it even has outside referrals, right? So it has all, like there's a component potentially on many levels, so it's a lot of different people at the.
But if there's dissension among, is that pointed out in the staff report? So say,
Yes, I mean.
because I've never seen that, I've never seen one.
Generally what happens just from a process is an applicant comes for a pre-application meeting where they say, here's what we want to do. We have planning, engineering, fire, and building sometimes sit in that meeting, say, oh, you want to do that? Well, here's the process that you need to go through. So for rezoning, then it moves forward and gets submitted. Generally with any type, they submit now the formal application, and you get about 4 to 6 to 8 weeks, depending on how busy we are, review turnaround. So you get your first round of comments, and the comments will say, did your application meet code? And whatever code that is, zoning code, anything traffic or drainage wise, and applicants get comments. They have to respond to those comments because generally not everything's met as far as the requirements. So then they get issued those comments, they submit another round. Generally, most applications do 3 or so technical round of comment and review of their application. And then majority of applicants do want to bring things forward to Planning Commission and Council with a favorable recommendation. So in order to do that, you have to make sure you've met all of those requirements. So the majority of what you see in front of you always has a favorable recommendation. Since I've been here, we have done one where applicant wanted to move it forward, and it did come with a non-favorable recommendation. But generally, applicants want to bring it forward with a favorable recommendation.
And with that first review,
Yeah, which one was that?
It was the Littleton mixed use project.
Which one?
Littleton mixed use.
so.
Was it PDO?
PDO, yeah.
It wasn't that long, it was fairly recent.
Yeah, it was fairly recent, but generally that's why it takes a while, and that's why there's so many rounds of comments before things come before you.
And the referral agencies comment in that first
too.
submittal. So when we get an application in, there's a lot of, shuffling that goes on behind the scenes and like trying to get stuff out right away to let the referral agencies have an adequate period of time. So we send to adjacent jurisdictions, Arapahoe County, Douglas County cities. We send to water, we send to XL Energy,
South Suburban,
Suburban,
just
urban drainage,
public health sometimes,
public health.
depending on what it is and what
If they have a kitchen or a pool or certain things that Tri-County Health looks at, it's a variety of referral agencies that we send it to, and they give us comments. So the staff report that you're getting is a collective report from everybody, and so that's why when you get it, it wasn't just thought of and hatched up one day. I mean, it's gone through and been through the process.
That's not just Carol's opinion.
Correct. No, Carol will not give an opinion, so no, it is staff is the collective, so.
Okay, that's good to know. Thank you.
Robin, do you have any questions, comments? One thing I wanted to bring up, you brought up the comprehensive plan. We obviously, what we have so far is a conceptual plan.
Yes.
Very much so.
Yes.
Or as I call it, a prologue. In the future, my vision of the comprehensive plan and with the future items being included would be more regulatory, including the area plans, corridor plans, neighborhood plans that need to be updated, also the downtown plan, for instance. Those would be more regulatory. So it'd be kind of a blended comprehensive plan. Would you kind of agree with that assessment?
Well, it really does. I'm going to use, for an example, Arizona, which mandates regulatory plans for all jurisdictions. You actually have 15 distinct elements in that plan, and then the statute envisions that you have actually regulatory area plans that also have regulations that hook into that general plan. And that's sort of the opposite end of what we see here in Colorado, which is a very, very regulatory. In fact, in Arizona, the general plans actually have to go and be approved by the voters. And every 10 years, you have to go to the voters, and the voters have to pass on the general plan. And that's how far and how regulatory it is versus a traditional, more comprehensive plan that's conceptual. And there can be a mix. I think one doesn't have to go to what I'd call the Arizona extreme over here, or if you look at some other states, the plans are extraordinarily conceptual. So I don't think you have to go to either extreme. There may be a place in the middle that is the best place to be.
So Jocelyn, when we're looking at the Bellevue corridor, are we looking at it strictly conceptual or a mixture of both?
Generally, our direction has primarily been more conceptual in nature. We certainly have some elements of our planning documents that are more standard, if you will, standards. I'm trying to think of different terms to use. The downtown design documents, for example. As you know, in those downtown design guidelines, there are standards and then there are guidelines, and generally that was adopted, so applicants must meet those standards that are in that downtown design guideline document. We need some different terms. Anybody else?
I mean, you could have a conceptual plan with the plan saying, and by the way, we are going to have these design standards that will be mandatory, even though the plan may be conceptual. And
so that's what we could do with the Bellevue corridor. Is that something that's under consideration?
So I think let's just work. I believe part of the idea with the Bellevue corridor is we would have some element of design, right, as a component for future. And so when we work towards that, we should be thinking about how we want to actually create that structure.
And that's something that I'm sure that working with Jocelyn's staff, we'll probably sort of put together some frameworks to come back to you on how this might look. How do we get that mix?
Skeletal outline, which I
Yes.
can't wait to see, and then we fill it out, flush it out.
And that's kind of it. And we may have a pyramid for you, and we'll have the frame of the pyramid, and then you'll have to fill in the pyramid.
Piece of cake. Okay. Is that it?
That covers all that we have to present.
Any other questions? Thank you.
Thank you so
That
much.
was helpful, thank you.
Yep, very good.
You want to take a break?
What's that?
You want to take like a
5 minute
5-minute
break?
break?
5 minute break.
I want to see this. Okay.
Creator of life, reveal yourself through the sun as the shining light. Creator of life, reveal yourself through the rain as a cleansing flood.
Jocelyn, take it away.
So in your zoning code, there is a chapter on it talks about special exception permits, and those are approved by the planning commission. So we're gonna give you some background on that.
Anastasia Urban, Development Services Manager. And I'm Carolyn Brown, Water Resource Manager, and I also act as the City Floodplain Administrator.
Okay, and you see our tags. Let's introduce ourselves.
Brian Corbett.
Robin Schwarzenegger.
Mark Rednicki.
Bruce Long.
John's not here.
And then all of the other planning commissioners that are absent this evening have said they will watch this on TV.
Okay.
So with that, we'll turn it over to you all to take it away.
All right. Well, there was a little bit of an initial floodplain primer done by Urban Drainage and Flood Control District back in January. I'm not sure if all the commissioners were present for that. So what we thought we would do is do a little bit of a refresher on some of the key points from that presentation, and then drill down a little bit into how the floodplains are actually regulated here in Littleton specifically.
And can you speak loudly enough?
Sure. What we thought we would start off with is just re-showing a video that Urban Drainage showed when they came in January, and it highlights wisely developing the floodplains as an amenity for communities to meet multiple benefits. And so I'm going to go ahead and just show that first.
Demo lights, mood lighting, or
Flooding is the most common and most costly natural disaster because more people are living in the floodplains. Floodplains are low-lying areas along rivers and streams that are normally dry but can occasionally flood. While flooding can be costly, we can work together to prevent its negative impacts by using the floodplains as a community asset. That means using the floodplains for water, open spaces, parks, and trails. Using the floodplains as a community asset will create beautiful places near which people want to live and work. It will save the community money, as well as protect businesses, people, and their homes. Join us to use floodplains as a community asset. We can all work together to use the floodplains as a community asset. Local governments want development because it brings jobs and taxes to help their communities grow and thrive. But wise use of the floodplains can create jobs and boost the local economy too. For example, Denver, Colorado is set to develop the South Platte River Corridor to include retail and residential development, as well as open spaces and parks. Over the next 20 years, this is expected to generate 22,000 jobs, $550 million in additional economic benefit to Denver residents and businesses, and up to $4.3 million annually in the new revenue for the city. And in Texas, the San Antonio River has experienced flooding for centuries. But with the public's support, San Antonio is working on a plan to restore historic and natural resources, promote economic development, and provide the community with a resource they can access and use.
It was a very pleasant surprise, and it's one of the most incredible things I've seen in my life, actually, to see what looked like a drainage ditch suddenly become a really nice city park, and it's just a block away from home.
By wise use of floodplains, local governments can create communities where people want to live and keep people safe from the impacts of flooding. It makes sense for local governments to use floodplains as a community asset. Join us. Developers can use the floodplains wisely and continue their business's success. Wise use of the floodplains helps developers have lower construction, operation, and maintenance costs. For example, outside of Chicago, Prairie Crossing included 350 acres of open space for farms, wetlands, and parks, saving $1 million in infrastructure costs through smart design. Wise use of the floodplains also helps developers make more money and better market their development to residents and businesses. In Charlotte, North Carolina, developers found massive success in marketing their mixed-use project near the Little Sugar Creek Greenway. The 15-mile-long greenway attracted residents and businesses to the area. The Metropolitan Luxury Condo development next to the Greenway sold to investors for $94.5 million. It makes sense for developers to use floodplains as a community asset. Join us.
Available on Urban Drainage's website, so anytime you guys want to look at it again, it's right there, and I'm happy to give you guys the web address link.
Again, if you could speak up a little bit.
Sure,
The room
sorry.
has bad acoustics.
All right, well, I already introduced myself. Again, I'm Water Resource Manager here at the city, and one of my duties is as the City Floodplain Administrator. So I'm sure we'll be seeing each other again as we get some of these expected floodplain permits coming in for some new developments in the city. It's just a refresher for something I think Urban Drainage went over a little bit with you all, is floodplains are regulated at the federal, state, and the local level. So at the federal level, it starts with FEMA and the National Flood Insurance Program. In Colorado, the state agency is the Colorado Water Conservation Board that also regulates floodplains. And then at a local level, because Littleton is a participating community in the National Flood Insurance Program, we also have our own set of regulations here at the city level, and that's administered through the Public Works Department. And while I put up Urban Drainage and Flood Control District's logo there, because even though they're not a regulatory agency, they're a tremendous asset in the Denver metro area. They're a quasi-governmental agency, but mostly they're a resource for local governments to help them meet their floodplain regulations and adequately maintain and manage their major drainage ways. They provided a lot of funding for maintenance projects and construction projects as well, and also help in developing design criteria for developers and engineers. So we're lucky to have that here. Slide is a little bit light, sorry about that, but just as an overview, the Urban Drainage and Flood Control District covers a large portion of the Denver metro area, starting up in Boulder County and extending down south to near Castle Rock, not including Castle Rock. The star there is where Littleton is located, and that shows you it's hard to tell, but the general boundary is, it's not gonna work, is it? Oh, there it is, right here. It's kind of this boundary here. All those little blue lines in there are all the streams and floodplains that they help the local governments to manage. And Teresa Patterson and Terry Fade came here on January 23rd earlier to give a brief presentation on floodplains in general. So here. I wanted to talk for a second about the difference between FEMA and local floodplains. This is a snapshot of the floodplains in Littleton. The lighter blue are the FEMA regulated floodplains, and the darker blue areas are what are called the local floodplains, meaning they haven't been mapped by FEMA, or they're in a state of revision and they haven't yet been adopted by FEMA. In general, FEMA doesn't map floodplains or assign floodplain elevations unless it's more than a square mile in drainage area for a basin. But obviously there are still flood risks even for basins that are smaller than that, and so urban drainage has developed studies all over the metro area to help map those existing flood risks. And so when we talk about local floodplains, we're talking about those other floodplains that FEMA has chosen to not map. And just
chosen to not map, or hasn't?
What's that again?
Has chosen not to map them, or hasn't gotten?
Well, FEMA generally won't map them if they're small enough of a drainage area.
Okay.
They won't do it.
It's because they're less than a square mile.
Yeah.
Right?
Yeah. So just in general, let's see. Big Dry Gulch is the northernmost regulatory floodplain, and then we have Slaughterhouse Gulch and Little's Creek and Lee Gulch and Rangeview Gulch, Jackass Gulch, and Dad Clark Gulch, which comes out of McClellan Reservoir. And then, of course, we have various pieces of the South Platte that run through the middle along the Highway 85 corridor. And on the other side, a lot of the floodplains are in Columbine Valley's jurisdiction, but we do have a little bit of what's called Drainageway D that's in the city of Littleton. Really great name, right? Dutch Creek and Coon Creek come together in a portion of Littleton over here. Then we've got South Jefferson County Drainageway, another great name, north and south, north here and south here, which has two different tributaries to it. So that pretty much encompasses what's in Littleton anyway. And obviously this isn't the easiest to read, but you can always go to either the FEMA website and also to Urban Drainage and Flood Control District's website. And you, these are the addresses for those, and you can actually type in your address and see what's nearby in terms of floodplains.
Could we have a copy of your presentation?
Oh, sure.
Just to have it there, not
Yeah, absolutely. When urban drainage came out before, they did a general overview of some of the floodplain terms that you often see on the floodplain maps and in the code as well. That lighter blue line that I've drawn in there, that's representing, this is a cross-sectional view of the channel and the floodplain. And that light blue line represents where the 100-year floodplain is estimated to be. And the elevation assigned to that is what they call the base flood elevation, or BFE. And then, so that's the overall floodplain, and then there's a zone inside the floodplain that's called the floodway, and that's the portion of the floodplain that's considered most important for conveying the 100-year flood waters. If you were to envision squishing that floodplain with development, like the example that's shown is fill with a house on top of it, but if you were to squish that floodplain, how much can you squish it before you see an unacceptable increase in water surface elevation? Does that kind of make sense? If you were to go like this, it's going to rise up. And that's used to define the floodway itself. And one thing I wanted to go through, most floodplain maps and ordinances and codes, they talk about the 100-year flood, or the 1% chance flood. And it's important to understand that the 100-year flood does not mean it happens once every 100 years, which I think is what a lot of people think of it as. What it is it has a 1 in 100 chance of occurring or being exceeded in any given year. So even though floodplain regulation focuses on that 100-year floodplain, there are floodplains for all other flood recurrence intervals. There's a 500-year floodplain, which has a 1 in 500 chance in any given year. there's a 5-year floodplain that has a 1 in 5 chance of occurring in any given year. But it just so happens that the 100 years sort of focused in on for regulatory purposes. Here in Littleton, we're a participant in the National Flood Insurance Program, as I mentioned, and as a result of that, we've developed floodplain regulations that either meet or exceed federal and state requirements. In Littleton, we're meeting the state requirements, which actually are in some ways more stringent than the federal ones. And as Jocelyn and Carol were talking about earlier, our floodplain regulations are contained in Title 10 and Chapter 6. And I wanted just to kind of present a fictitious example of a project that might come in that would be required to go through what we've been talking about as the use by special exemption process. Any work that occurs in the floodplain really needs to go through some scrutiny in terms of whether it's going to cause an impact or not. And the process we use for that is this use by special exception. This example is, I'm just saying, a housing community comes in, they're called Riverview, let's say, and they're next to the Little Tonia River. This is all made up. Okay. And they want to bring in a lot of dirt, and they're going to put it in a portion of the floodplain and put the houses on top of it. So if that solid turquoise blue line is where the floodplain is today, and they want to put fill in the house in it, it's going to probably change that floodplain. It's going to narrow it a little bit, and it might raise the elevation, and that's kind of what I've tried to depict there with the darker blue line. And so what we require of applicants is that they perform a hydraulic study in order to find out and evaluate how is the floodplain going to change, and does the concept for that fill or that development work so that they still can meet all the other portions of the code, such as elevating houses up above that level.
So a hydraulic study obviously has to do with how much water is moving where, but who does that?
The applicant will hire an engineer.
An engineer
who's
and
proficient in doing
models
that.
that they use to forecast this, which are more or less accurate, do we know?
Yeah, and I'm going to talk about that in just a second. I'm going to drill into that, but yeah.
Is there a situation where you get what we call it, a company by hire that'll shop around until you get one that you know is liberal?
I suppose that could happen. But as we're going to talk about in a little bit here, these studies come under a great deal of scrutiny, not only here at the city, but we also send them out to referral to agencies like Urban Drainage, who also have a lot of experience looking at these. So if, I don't know how the right term to use, but if it's not quite right, or their results are quite accurate, or are slanted in any kind of way, that will normally be picked up on.
Do you, if you get an application, do you always require them to do the hydraulic study, or is it times where it's so preposterous a proposal and just say, get lost, it's not worth the effort?
Due process, remember we talked about
Yeah.
We can bring you preposterous things, but they will be scrutinized.
Okay.
And so the process, once that applicant comes in with their project, the process is identified through section 10.6.8, where they submit that special use by special exception permit, which includes that floodplain study and their delineation of what they think that proposed floodplain is going to look like with their project. And then the city's floodplain administrator and the staff review that. And as Jocelyn was pointing out before, it might go through multiple rounds of comments and responses in order to make sure it meets all the requirements of the code and technically is a sound analysis. It also goes out for referrals to a lot of other agencies, including Urban Drainage, and oftentimes Colorado Water Conservation Board as well. A lot of times they'll defer to Urban Drainage because they handle most of the projects that occur in the metro area.
We would also send to the state engineer's office and the Corps if we needed to.
Right, that's right. Yeah.
Corps of Engineers, yes.
Yes, the Corps, U.S.
Doesn't understand that.
Yeah, sorry. Engineers.
You have a review, a use by special exception, but then I read about this, there's a whole section about appeals. I assume
Right.
that's also kind of goes through the same
Right.
process,
If-
quasi judicial.
Yeah, I mean, and correct me if I'm wrong on this, but if we were to go through a review and we made some determinations about the application, or we found some deficiencies or whatever, and they didn't like the city's position on it, they could appeal that. Is that correct?
So yeah, it's not a use, it's a technical appeal exception.
For some decision, yeah.
Yeah, okay.
Yeah. And then assuming that the applicant has met all of those technical requests and criteria that the staff has asked for, and through the referrals as well, then we would recommend it to the Planning Commission for approval. And then you would review that and approve it with conditions, or deny the application that comes in. So review by the floodplain administrator, we talked about this a little bit ago, but we'll review the application to make sure it meets all the requirements of 10 chapter 6, not just 8, but 10, all of chapter 6. We'll do a technical review of all the hydrologic and hydraulic modeling and the validity of the results, and we'll send it out to referral to urban drainage and the other agencies that we were mentioning. And you know, the point here is that there's lots of eyes scrutinizing these applications.
And those referral agencies are actually called out in the code, which is not typically our other code sections don't say which referral agencies. This one in particular calls out so that we're getting all the agencies.
This whole process is just triggered by any kind of application that's in a FEMA or local floodplain, even a small portion of it, anything that touches one of the,
Anytime they want to do development that would impact the floodplain.
Yeah, and the term development is quite broad. It's pretty much any man-made change within the floodplain. Even if they wanted to, if someone's house was in the floodplain and they wanted to build a garage, they'd have to go through this process. Or they wanted to expand their home, they'd go through the process.
To clarify one point, if they're not going, if the applicant's not going for a use by special exemption or an appeal, Planning Commission never sees this.
Right.
Just goes through the standard, what do you call it, staff analysis and FEMA, what have you.
Yeah. Yeah,
Okay.
I mean, if this is the process they would have to go through if they want to build in the floodplain.
Yeah.
I mean, that's the case if it's a use by right zoning project?
Yes.
in the
So
floodplain.
if you had a B2 property, for example, that wanted to do an expansion and it would impact the floodplain, and there's like Carolyn showed, there's all these little fingers of these floodplains all over the city. They would have to go through this for any portion of the development that would impact the floodplain.
I'm still not clear. Applicant comes in, he wants to go into the floodplain somewhat. He's not going for a change or a special use. He's not going. He doesn't appeal for. He goes through the appeal process. It's just a straight. I want to go in. We don't see that. Is that correct? We don't see that as a planning commission.
Yeah, the process is.
If they're going into the floodplain,
Yes.
it comes to planning commission.
Yes. 6-8A.
Okay, under what, use?
6-8A.
Okay.
So
Any property owner or a designated agent may request permission to develop property located within a floodplain by filling out an application.
So if there is such application, it has to go through the planning commission. It can't just be the floodplain administrator.
That is correct.
That section again?
6-8.
I'm sorry, 10 who, what, did?
10-6-8A.
10?
Procedure.
What's that?
If I could just offer maybe a clarification, there are projects, there are drainage components to projects, and so projects may be outside of a floodplain, but we have other stormwater regulations such as best management practices and detention. But doesn't touch a floodplain. Those are the types of projects that are reviewed by staff administratively. And so going back to that map where Carolyn showed the light blue and the dark blue, any properties that impact that, again, kind of if they touch those floodplain areas and are proposing to modify, fill, change, alter, developed as defined in the code, that's where Planning Commission would see those applications. Generally, I mean, when people are looking for properties, and floodplain is kind of one of the big questions. Do you have floodplain and do you not have floodplain? Because it adds that extra level of engineering review and Planning Commission review in this case, so.
But yeah, but currently there really isn't an administrative only process for working in the floodplain. That's something we might start looking at for really minor projects that don't involve a change of use or, you know, on the property.
We're not engineers, we're not hydrologists. It could get just overwhelming for us.
Sure. So we've been talking about that, but currently there isn't really something like that right now. Just to take a step back a little bit and talk about what we mean by hydrologic and hydraulic modeling. Just for those who aren't very familiar, hydrology is essentially the study of how much of the rainfall actually makes it as runoff into a river or creek or drainage way. And like I was mentioning, you know, urban drainage has developed a lot of computer models for the Denver metro area that are specifically calibrated to the rainfall here and stream gauge data. And stream gauges are instruments on rivers and creeks that measure how the water level changes and the flow changes in that creek. So they've taken a lot of that data and really refined these local models for use around here. They also call them rainfall runoff models. So this is just a schematic of the hydrologic cycle, and so most of these models are just, they're interested in, if I can get my little, see the precipitation side, there's all these other losses where water evaporates or transpirates back into the atmosphere, but what these models are really honing in on is how much of it ends up as runoff, which you can see down here. And this is the component that ends up in the creeks. And then once you've done your hydrologic study to figure out how much water is going to be running off on the surface, then you put that into a hydraulic model. And the hydraulics is the study of how deep and wide and quickly that water is going to move through that drainage way. The way this is done, this is just a 3D representation of just a generic landscape, but you take the water from your hydrology study and you kind of basically dump it onto the landscape and let it run through there, and it generates depths and widths of what that water will look like based on a lot of assumptions about flow resistance, such as like how much vegetation's in that drainage or creek, how rocky is it, are there houses in the way, that kind of stuff, which would add to flow resistance and would change the depth of water. All of those things are components that go into those models.
Does it take into consideration the build out of a site, like an area? They anticipate those, or is that, how does that?
Well, as part of the hydrology study, they'll make assumptions about all of the land use in the area. In the Urban Drainage and Flood Control District, when they did a lot of these, when they first started doing a lot of these studies in the 70s and 80s, they assumed full build out on a lot of them because they wanted to identify what that eventual future risk was once those communities fully developed. There are some differences between FEMA floodplains and local floodplains in that regard, in that FEMA maps the floodplain based on existing land use. They won't map and require public to pay flood insurance based on a floodplain that isn't necessarily in existence yet, because it's based on a future developed hydrologic condition. So there are sometimes some nuances there. But in Littleton, you know, because most of our basins are fully developed out with very small exceptions, the full build out is what is used for those delineations. And just to kind of give you an idea of what some of that hydraulic modeling looks like, this is some graphical output from one of them. I'm an engineer, so I like this kind of stuff, right?
You'll be tested.
I rest my case.
Yeah. So, you know, by far the most common hydraulic model is called HECRAS, and what it does is it gives you output it gives you the depths at any given cross section in a stream for that event, and it'll show you in profile view, which is up in this corner here. If you were to cut a slice through the drainage way along the length of the drainage way, this is the channel bottom elevations, and then the water surface would be up here, and this might be a bridge or a culvert or something like that. You can also you can also look at it in cross-sectional view. Again, you can see where that water surface will be in relation to the bridge, let's say.
and it gives you a lot of tabular output. And so all those elevations are then taken and then they're draped essentially onto the landscape to give you an aerial view of what that overall floodplain would look like. And this was taken, this is one of the pictures actually that was in that video that we looked at before. This is Westerly Creek up there near the old Stapleton Airport development, where they really put a lot of effort and attention into developing the floodplain as a community amenity up there and leave that floodplain reserved for recreational uses and keep all the homes and structures well outside of that flood risk. So that's kind of our primer. I don't know. You got any questions?
So, I mean, the one question is they're going to present some distillation of that information to us as developer will come in with an application to do this, so then staff, you all review it. And what the criteria to approve it then is what? Just recommendation? I mean, normally we would have code or we would have something that we have to say, okay, this is consistent with something. So what is the criteria we're going to look at?
10.6.8, it's in the code.
Let's make it simpler.
What does it say?
The commission is looking at this from a technical standpoint. And what that means is that your function is, again, we talk about a regulatory body, which means that you first start as a preference in terms of deferring to the expertise of staff. So you start with the fact that you defer to the expertise of the agency and you look to see if the recommendation from staff is in some way arbitrary, unreasonable, or capricious. So I actually have litigated a number of floodplain, and I've seen these. This brings back not so good memories. But for example, you would look at, staff would say, yes, this particular development, there's been a regional hydrology study done by the Urban Drainage District that looks over a 2 square mile area, as well as the local hydrology study for the development. The staff has evaluated the developer's proposal to convey the drainage through the development by the use of 2 channels, and they propose to install box culverts on mineral. However, the staff has looked at the hydrology and determined that the box culverts are undersized because they will not carry the sufficient volume of water. So the staff would only recommend the use by special exception if the box culverts were increased in size. And the only problem with that is the developer doesn't like the fact it's going to cost them an extra $1 million, which is why we're here. But the staff would look at it exactly in that context.
Okay. But we're also looking at, it's not just staff we're judging by, but we're also, obviously, the public has input. We're quasi judicial, so it would be a public hearing.
This is
regulatory.
This is regulatory?
This is
This is a regulatory.
No applicant presentation?
The applicant can certainly provide you comments, but you're really looking at the agency judgment, not the applicant judgment. Now, you would normally have a report from the applicant because they're in front of the staff and you will have them, but you're really not basing this like a quasi-judicial, you're really basing this as a regulatory item. And what the applicant is going to try to argue, if I was a lawyer for the applicant, I would say, well, wait a second, the staff is being unreasonable. These box culverts, which are a single 4-foot box culvert, one would be sufficient. Here's why. Here's what the drainage study would say. And the staff position that we need to have 3 6-foot box culverts is unreasonable. And that would be and if I was the applicant, I would say my hydrologist has said these reasons are why the 4-foot box culvert would be sufficient. And but you're really functioning in a regulatory capacity. So the applicant is going to certainly have a position, but it's not the same type of due process that you would have in a quasi-judicial.
So, similar to what you've seen in when we saw some other applications where the applicant goes through point by point and talks about how they meet the criteria. The criteria outlined in 10.6.8b, floodplain development requirements. The applicant is going through that analysis and providing that as part of their application, and it will be part of the staff report that talks about how they meet those requirements.
So they talk about the board shall adopt procedures for conducting public hearings. Public hearing is staff information prepared by you, information given by the applicant, and we don't have an open hearing with public input, public comment.
Right, it'll be, but
It isn't the same way. If you look at 10.68b, it does say the commission shall conduct a public hearing to receive technical evidence and testimony from city staff, the applicant, and opponents, if any. So it's not like a normal public hearing where you're just receiving comments. It's really focused on any technical evidence. Either the applicant, in theory, an opponent would be perhaps a downstream property owner. If you're doing this project on Mineral and they were only doing 4-foot culverts, as a downstream property owner, I might have a concern that the volume of water coming through that culvert is going to be so fast that it is going to increase the possibilities of erosion on my property. So I might well come in and say, you know, the city staff in approving this 4-foot box culvert never really considered the erosion on downstream properties. And you should reject it because they didn't consider the erosion on downstream properties.
So I have some questions specific to what's in the code. Under the definitions, special exception
Where is that?
is under definitions. The special exception, that's the term. I have a specific question about.
So 10, chapter 6, section 2.
Chapter 6.2, a use which may be permitted in a floodplain upon approval by the commission, into which the commission may attach specific performance requirements. If that was to happen, normally those are again going to be something your staff is going to recommend. Because, for example, it may be that what we've determined based on the hydrology study is that building at what we call finished floor elevation, which is that base elevation, isn't sufficient because of the addition of fill. So the staff recommendation might be that all buildings within this development need to be built at 2 feet above finished floor elevation because of the fact that the addition of the fill into the floodway is going to increase the flows and conceivably have them top over the base elevation, and therefore the buildings need to be elevated. And it would be those types of special exceptions that staff would recommend.
Well, and we would normally require that they figure out what that change to the floodplain is, and then they have to show that their developments are going to be actually a foot above that.
Yes.
That's what's in our.
And so, Steve, is it fair to say that we're not looking at the use? I know it says use by special exceptions. It's talking about the use of the floodplain,
Yes.
not uses of property.
Not the use of the property, the use of the floodplain, and how the use of that floodplain is going to affect these types of things. And that, again, is all going to be based upon a hydrology study, because we're going to be looking at the increase in elevation and flows and those types of factors in making that recommendation to you.
So the bottom line is we as a commission do not have to come up with these specific performance requirements.
No, we would certainly recommend it.
But we do expect you to do the HECRAS files.
We will send you all to college and make you in 4 years hydrologist.
5-year process.
I actually do have some experience in hydrology. I used to work for the Department of Energy, did river operations, but from a different perspective than what we're dealing with here. So this is not my purview. So I have 2 more questions, and this is in 10-6-8. Under A, the procedures, 1, application, F. If that's not too confusing.
Yes, I mean, what that envisions is that they, as part of their land use application, they're going to have to file a separate application with the floodplain administrator. That's going to be the technical document that's going to begin to generate this review. And what I think, Jocelyn, we would normally do if you came in for rezoning and you had property in the floodplain, we through the pre-app would say, okay, now you need to file a zoning application for this, but because you have property in the floodplain, you're going to have to file a separate application to address the special exception issues.
And it's also looking at downstream impacts.
Yeah.
That you're not impacting. So you can't just say in isolation, I'm only looking at my site. I don't care about anybody else. The river will, or the stream or whatever will go and impact other people. You have to look at the system as a whole. And so that's...
So my specific question is the commission, as us, may require an applicant to furnish additional information. This is on the adjacent properties. I want to know what we're talking about when we say adjacent. Like you were just talking about downstream, that's not physically adjacent, but it's affected by it. What aspect of adjacent are we looking at? Just physically touching it, down the stream?
What that would normally be done is that would be part of the hydrology study. We would look at normally when these are done more, and again, I'm going to at some point defer to the engineers here, but these are done many times in terms of a regional drainage basin where we'll look at everything in terms of things within that basin, because you may be at the top of that basin and you're going to affect things at the bottom of that basin, so to speak. So really this becomes, in terms of those properties, it's going to really be based upon the drainage study, and what that drainage study shows us is the impact.
It just says commission may require additional information, and I'd like to know what that would look like as a commissioner, because again, I'm looking to the experts to probably fulfill that, but it does say commission can ask for more information.
So that would be more like, Steve, if they thought the study didn't look at the impacts to the properties, or if you needed...
Yeah, I think what would be more information would be, for example, if the study submitted did not analyze, for example, the impact on downstream properties within the drainage basin. It only looked at the properties directly adjacent. What we would normally want, we'd say, listen, you need to look at everything within this drainage basin. And I've had this with developers that said, well, that's 3 miles away. And it's like, that's okay. You have to look at that too and determine if anything you're doing up here could have a negative impact at the opposite end of the drainage basin. And
So I was just going to mention it. So it might be like you might ask for them to extend their hydraulic analysis further downstream, because they might just do it right on that site and terminate it right at the property boundaries. So we may, the administrator and or the commission might say, well, no, you need to extend that further down to where this particular creek meets the next one downstream. That kind of thing. That's just one example of something.
And a lot of that happens initially in the review cycles, where Jocelyn said typically even on planning applications, there's 2 to 3 review cycles where we're reviewing it and we're saying, well, show us, a little bit more, you're missing some information. And not only downstream, but upstream you have to be careful of too, to make sure that you're not kind of causing a bottleneck and causing water elevations to rise.
That's
on the other side of
you
development
can't increase
too.
flood hazard on upstream properties either by your development.
So most of this is probably going to be accomplished before it gets to us, in that sense, just like the other answer was.
Either staff will identify all those kinds of issues, or it'll come in through the referral process, like the downstream property owner may say, well, wait a minute, how's this impacting us?
And so all that information will be passed along to us, so that we'll be able to look at that. Okay.
And you may see some additional conditions of approval that you might not see on other cases, where we would say, we've been through to get them to the hearing, we could say, well, the applicant has presented this, staff believes this, therefore an additional X, Y, and Z needs to be required as part of the approval. So you might see some additional conditions or things that normally the stuff it's a little bit neater and cleaner, but since it's such a technical exercise, you may see some other stuff on there.
Hopefully we will have vetted all those before it gets to you.
Is it common for planning commissions and other communities to be involved
No.
Which begs the question, why are we involved?
Because it's
1992 and ask somebody.
It's probably what you'd see in most communities, and someday this question may get raised with the council, is you would have a technical, what we call either floodplain or drainage board of appeals, which would usually have, say, 5 people with different technical backgrounds who would actually review these. And you would not have them go to the planning commission. And I would prefer that, frankly, to have that process with no disrespect to the planning commission. But these get highly technical, and you really, having tried a couple of these as a lawyer, I still have memories of struggling through this stuff, and without having an engineering degree, and saying to the city engineer, now, what does this mean? And they walk me through this in non-engineering terms. Now, by the time I tried the case, I actually understood it.
I do have one more question, and it's just a little farther down. It's under the commission action, and it says, and in C, so if you took from F and then you go 2, 3, 4, 5, commission action, and under C it says, based on the evidence and testimony received and based on the objectives and policies stated in section 10-6-1 of this chapter, the commission shall make its decision on the application. When you look at 10-6-1, we're looking at things like human life and health, expenditures of public money, minimizing the need for post-flood rescue and relief, blah, 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 blah. You know, again, I'm assuming that this stuff is going to be vetted through you guys, because this is above and beyond.
Yeah, that's correct.
Yeah, we'll be looking at all of the components of chapter 6.
And that explanation, again, just because as a commissioner I'm supposed to do that, so there'll be like a section we write up saying we've looked through these things and this is what we found.
Yeah. And oftentimes we'll ask the applicants to go through each one of these things and address how they're meeting that.
And then pass it along to us so we can at least do our due diligence, which is I can read.
And how that can play out in reality is an applicant may say, well, I propose on this small channel that I would like to do concrete riprap on this small channel because it's so much cheaper than to do it in the natural state. Now what the city is going to say is, well, friend, we prefer the natural state. Concrete riprap can be kind of unpleasant to look at. On the other hand, sometimes developers will say, well, we want to create a new maintenance obligation for the city. So those types of things all get looked at in this process, whether it be how it looks or the fact of a developer wanting to stick a new maintenance obligation on the city at the taxpayer expense. We may well say, no.
And certainly to that example, both the city and urban drainage are heavily focused on naturalizing channels, not having a Los Angeles River type of concrete line channel that we want to naturalize.
Or what was proposed for the Platte River here after the flood.
Right.
Mm-hmm.
So, a question, and it's maybe, since we're going to go technical on this stuff, maybe it fits in. When they run the hydrological models, are they doing two things? I assume they're using sort of historic data, and I assume they're using more or less a base case. And so my question ultimately ends up being is, I kind of assume we do have some sort of responsibility given the realities of some level of climate change, however you want to interpret it, that maybe the historic base data isn't as legitimate anymore as it was 20 years ago or 15 years ago. And then should we be looking at sensitivity analysis at some required level of interaction with these models to just sort of say, what if? I mean, if here's your base case and it's based on historic assumptions, but you expand that and you run sensitivity analysis, you're going to get different answers, and then it's sort of up to you guys to sort of say, what's our comfort level? And you know, we totally have no way of assessing any of that, but on the other hand, it seems like questions that you guys ought to be asking. So are you guys going to ask those kinds of questions?
Well, the whole climate change and how that's changing the rainfall data and whatnot that goes into a lot of these hydraulic models is something that's being talked about quite a bit. I don't think they have quite drilled down on exactly how to approach that technically speaking, in how to incorporate that into the models. I do know that they have recently, there was one of the big sources for the rainfall data that goes into these hydraulic studies is from what's called the NOAA Atlas. And that recently went through a revamp based on new data, and they have new rainfall estimates as a result of that. I don't know that that really is bringing in climate change yet, but at least it's updating it based on more years of information based on what the rainfall is doing. So I think it's a constant conversation that's going on. I think over time that'll be brought into the hydraulic analyses, and they'll be updated accordingly. But so what they're doing for now though is sort of require, like we were talking about freeboard, requiring additional distance vertically above some of these floodplains to account for some of that uncertainty, climate change being one of them, just to give a buffer of extra protection to account for that.
But I mean, which isn't a bad answer, perhaps in a generic sense. I mean, you can just say, well, if your quote-unquote 500-year event is X, we want X plus 2 feet or whatever. But it's sort of arbitrary because we don't really know.
I would say the field, continues to evolve. Yeah. And we were talking that we've both been in communities where the base rain events was so many inches per 24 hours, and then new data comes out and that base rain event changes. So it's not just 1972, here's a rain event and this is what we're sticking with. So we've gone through places where that rainfall data has changed, and then the stream gauge data, I think, is fantastic technology that didn't exist when a lot of these, or didn't exist to a certain extent, because now even, if you're a boater, a rafter, or any sort of water sports person, you can go and see stream gauge data from your home and see how fast, how high, how everything's running, and so the fact that we have that information at our fingertips, where before you were going through charts, that were published in books, and so the amount of information available to designers now is immense compared to 20 years ago, I would say.
Well, which is good, and I don't want to belabor this because it really is a technical thing, but I guess on behalf of the community, you want to strike the right balance, right? At some level you want development projects that are in the best interest of the community to be done, but on the other hand you want infrastructure in place that maybe has a somewhat higher tolerance level than what we've required in the past, which is expensive and unlikely to be, and maybe detrimental to good projects getting done, because nobody wants to spend the extra money unless it's absolutely required. So I don't really know where that balance lands, but I think you guys need to have those conversations.
Absolutely, yeah. For instance, our freeboard that Carolyn talked about, our code requires the building to be one foot above that base flood elevation. In the community I came from in Minnesota, we require 2 feet above that base flood elevation. So that's certainly a decision that the commission and the council could make to have additional levels of protection.
And there is additional clearance of 2 feet required for critical facilities like hospitals and things like that, but other developments.
And certainly as these studies, many times there'll be regional studies and things which are updated. And obviously as we update the studies, then the modeling changes to reflect the updated studies. So it's not like the situation where these studies are cast in concrete and never updated. The Urban Drainage District is continuously looking at that, as well as other cities. We may find, for example, Englewood did an updated study. Are we going to look at the updated study as part of this? Yes, we would.
And if they're using an older study, they have to prove that older study is still valid, correct? They just don't get to say, I pulled this one off the shelf, it was done in 1999, and I want to use it. They have to prove that still is true in this case in point.
And many of our flood hazard delineation studies date back to the 70s even.
Some of them are rather dated at this point.
the basins were still had significant development at the time. So the rainfall data has changed somewhat too. One of the interesting things with the NOAA Atlas update is that some of the 100-year rainfall values in the Denver metro area actually went down as a result of that new data. And so there is some, I think, reasons to believe that our hydrology estimates that were done are still relatively accurate for Littleton. But that is definitely something that at the engineering department here that we'll be evaluating and talking to urban drainage about and really drilling in and say which ones of these do we really need to restudy.
Bring up a potentially ugly scenario here. We get an application, we read and analyze the mounds of information, hydraulic studies, your analysis of protecting the health, promoting the common good, protecting businesses, et cetera, and we totally ignore it, and a renegade planning commission votes either for or against something that's contrary to all your information. Can we be, and we are the final authority according to the code here. So what happens?
Not me. Unless the engineers want to say, but what could happen is a couple of different scenarios. One is because you're acting in a regulatory capacity, if the council, for example, thought you were being arbitrary, unreasonable, and capricious in your actions as a commission, occasionally you get a situation where the council ends up suing the regulatory body and asking under Rule 106, asking the court to overturn your determination. The other option, I mean, that does happen on occasion. I've been involved with that in my career a few times. From the other standpoint would be that if there was a code amendment or something that maybe caused the commission to take the action it did because they didn't perhaps understand or it was unclear, then certainly we as a professional staff are going to be taking a long, hard look at whether we need to make any code changes. Could the city be held liable? Yes, people will certainly try. One of the cases I had the pleasure, I won't say pleasure, but we litigated was a city decision to convert a floodway into a golf course. Don't ever do that. And use undersized culverts because the developer didn't want to pay for the full-size culverts on the roadway. And suddenly the developer, when we had a 100-year storm, found that the water was overtopping the golf course and running into homes because they'd significantly modified the flows of the channel. And did the city get sued? Yes, it did. And it was a very long, lengthy piece of litigation that we spent several years with.
Well, second part of my question is, can a planning commission decision be overridden by FEMA or Corps of Engineers or any other flood control agency, or not?
No, I think you're only subject to judicial review.
Yeah, and the use of special exception, your decision is only subject to judicial review. Now, this can again create problems in the sense of if you make a technical decision that's at variance with federal floodplain regulations, the federal government may decide to make us ineligible for federal floodplain insurance. So there are consequences to your decision. Judicial review, but there's serious consequences to the citizens of Littleton for making that kind of decision.
It's an interesting question, I think. A lot of consequences. Okay.
So one of our goals, or primary goal tonight, is to kind of help explain what goes into the review process and not just, here's a 40-page, stormwater report with all these data files and good luck. To put faces to names and kind of tell you a little bit about the review process so you understand kind of what happens before you see the packet. That review process, and again, going going through the modeling, and we do get electronic copies of their digital files too, so we have the ability to check their inputs, because paper copies and electronic copies, sometimes, what if something got manipulated? So we can always check their files, and also if anything, got really intense, we can always refer our review out to a third party as well, to another consultants if there was something that we were a little unsure about, even before, again, we scheduled it for a hearing. And similar to the way that you see traffic reports, there's an executive summary, probably just talking about the traffic. We would have an executive summary for you. Again, you're not just going to get that 40-page report and say, please, please review. You'll have kind of our findings and summary, attached to the cover. And if you really want to read the full report, it'll be there.
And if you want to open up and look at the HEC-RAS files with me, we can sit at my desk. I'll be happy to step you through all that. Before joining the city, I spent almost 20 years working on the private engineering side doing hydrologic and hydraulic studies, and so I'm very familiar with them.
Any other questions?
Just one question that goes kind of back to what we were talking about before with staff. And so because any use by special exception has to come through Planning Commission, right? And I'm not qualified to make an engineering and hydrology assessment. Your recommendations would accompany that, right?
Yes.
Because I don't even know what I don't know to ask questions for follow-up. So
if you guys look at 10.68B, all those floodplain requirements are in here, and that's what our staff report's going to be based on. Your decision's going to look at these pieces, and just for example, some of these things in here, talking about placement of fill material, putting manufactured homes. Don't put those in the floodplain. And so there's criteria for this that say you can't put manufactured homes in the floodplain. There's things, non-residential construction, there's criteria for that. What you do with the utilities, do you want the utilities in or out, or how they're dealt with, and are they deep enough, are they placed outside, are they, and this is fairly easy to get through this stuff. So our analysis will be this in addition to all the hydrologic modeling and technical documents. There's still criteria in here. So that's the piece that the engineering side supports all of this, but the applicant and staff are going to have to go through and analyze it according to this code.
It'll be generally how you see applications come before you, no matter what chapter in the zoning code, right? It'll go through the analysis of whatever the requirements are and the recommendations, as Carol is saying, and then the appropriate staff will be there to answer any questions. If you're like, oh, I see that you're saying it meets X, Y, and Z, but I want to know more about how you got to X, Y, and Z, that's where then you ask staff and we can present that information.
I don't need a location or a specific project, but is the reason we're going through this exercise mean that there's something coming down the pike that we'll be looking at that
Potentially, and I
involves
think
floodplain?
it's two things. Number one is I'm not sure that we've been as consistent in applying these rules and having things that should come before Planning Commission, so we're wanting to make sure that you have the background and awareness about this chapter and this requirement in the code. And then, yes, we have a few different special exception permits in various stages in the process.
Okay.
Whether they all come before you or not, that again is part of the process.
I'm glad we didn't get hit on a Friday afternoon with this for the first time.
Right. Yes, we didn't want
That's why
to
we're
hit you with that
practicing
either,
and
so.
going over stuff, and we did it in January, we're doing it now. We just didn't want it ready to go, whoa, what is all this math? I haven't had math since high school or college.
Mass resignation.
Just sign one resignation letter together with multiple signature lines.
Don't want that. Don't want that.
Okay, is there anything else?
And I was just going to mention that even though this is still fairly high level, any that you want to drill in and better understand, just let one of us know. We're happy
You
to-
guys, if you can reach out to me and I can get
Yeah.
you the appropriate info, or we can send it to everyone, and we'll certainly make
We'll
sure
send
to
it
send
out.
along both of these presentations rather. So you have that.
Okay, that ends the floodplain 101 course. Jocelyn, you have anything else you want to add? Upcoming events, anything?
You do have some meetings in October, as you may recall. And as those are finalized, we will let you know, so you know the addresses of the hearing cases, so that you can recuse yourself should you be asked about those. We'll follow up based on the conversation earlier about what we want you to do before the next hearing cases as far as site visits. We'll definitely get it on that to you soon. And then the last thing on the Bellevue corridor, I haven't given you an update on that. We have hired someone to help us with that project, and we're looking right now, but again, I'll let you know once we finalize it, to do the initial public meeting the third week or so in October. We're looking for a location somewhere out in that area, so not at the center. But again, we'll let you know.
We're not running the meeting, we're just, we can be observers.
Absolutely,
Yep.
yeah. So I'm hoping that you're all going to be able to come, but we'll let you know more. But I just had to give you an update on that project.
Your email said that in October is the breakfast with council as well.
Oh, yes, and you have a breakfast with city council on, here, Thursday, this can't be right. When is it? October 19th.
And then the session with them on the 24th.
And then the sessions, yes, and then you have a joint study session with council on October 24th. A lot going on.
It's a lot of work.
So, that's why we ended up with one. Anything else?
Joint study session is what topic? I can't remember.
The joint study session with city council on the 24th. The study session topic is the update on the draft mineral station action plan.
Okay, is that it? Thank you for all coming. Thanks for the input. Thanks, staff.
Thank you.